like to present you a one-day webinar on intellectual property rights, protection, enforcement, and business strategies. So we have two speakers for today's session, Mr. Dinesh Jotwani and Ms. LG Sujata. Mr. Dinesh Jotwani has over 25 years of experience of law, technology, and litigation with a focus on cyber law and IPR laws. Since 2015, he is co-managing partner at Jotwani Associates LP since 2015, which is a multi-specialist law firm based in New Delhi, India. It has a diverse practice areas such as government relations, intellectual property, corporate law, litigation, real estate, and immigration. The firm enables its client to achieve their business and personal goals. He also holds 2 US patents on e-discovery process used in litigation and investigation. He has authored a book, Interface Between Competition Law and IPRs, a global perspective, published by GIIP 2012. Earlier, he has been an in-house counsel, partner in law firms, and also an independent consultant to several technology companies such as NCR Corporation, Tech Ornies LLP, Microsoft, Symantec, and Evaluaserve Private Limited. We welcome you, sir. Our second speaker, Ms. LG Sujata, is an advocate with nearly 2 decades of experience in intellectual property rights, cyber laws, domain names disputes, trademarks. She is also a founder and partner at Kamakshi Law Associates, a law firm based in New Delhi, India, which has a strong team of legal professionals who are experts in the field of intellectual property and corporate law, and provides consultations, expert opinions, strategic advice, and litigation support to business, houses, and individuals. Ms. Sujata has been assisting clients with trademarks, copyright, intellectual property registration, and litigation services, resolving domain name disputes, besides dealing with assignments, licensing, agreements, and enforcement actions for Indian and international clients desirous of protecting their intellectual property rights. We welcome you, ma'am. And this news is for all the participants. If in case you haven't registered yourself completely, then you can register yourself in the link which will be provided in the chat box. And only students who have registered through the payment and have sent us the link will be eligible for the e-certificates, as well as a voucher of 5,500 to avail any course from our website. Thank you. We welcome you, sir. Please start.
All right. Thank you. Thank you, Shreya, so much. And hi, everyone. My name is Dinesh. I have been an IPR lawyer for nearly 25 years now. And as Shreya introduced me, I also hold 2 US patents. I am mainly a practicing lawyer. I go to court and currently handle a lot of enforcement also. So whatever comes out today will be from my personal experience itself. So any questions you have, anything, any clarifications you have, please ask me. I can see around 30, 35 people who have come. So I won't broadly go into the fact that formal introduction. I thought I will have formal introduction from everyone, but it looks like we are now around 35 participants right now, and it may be a little difficult. But what I know is we are all from diverse background here. It's not necessarily many of them are lawyers. Many of them are also from engineering background. I know some of them registered themselves from they registered themselves from science background, management background, and this is what my presentation is going to talk about today. All right. All right, so I will jump onto my presentation directly, and if you have any questions in between, probably you can put it in a chat box, and if I can answer at that time, I will try my best, and otherwise we'll take it up at the end. Okay, let's get going on this. I will share my presentation. Let's go on. People can see my screen, I suppose. Okay. Yes, I'll just go to the overview of intellectual property rights. And being an IPR lawyer for decades now, I can say that it's not a one subject specialization. It is a multiple subject. You need to be knowing various subjects. For example, I've seen chartered accountants to be part of IPRs. Lawyers, of course, they are part of IPR subject. Patent attorneys, marketing people, engineers, info security, sales people, human resource, that is your HR department of the companies, and also procurement. Tell me, and you can unmute yourself and perhaps answer me. How come the marketing people are impacted by IPR or the sales people? Because I was when I started my in-house job being an IPR lawyer for a multinational company, I was surprised to see so many interaction with the marketing and sales people coming to me and asking me to have information on IPRs and how we are protecting our IPRs. So I want this session to be interactive. I can speak on this subject for 2 days, but the idea is also for me to know how much you know about IPRs. So any guesses here? Anyone who would like to answer this can perhaps raise hands and then unmute himself or herself, and then we can interact more. So my question is, how was the sales and marketing people impacted by IPRs? Anyone? Yes, please. No one?
Hi Dinesh, hello everyone.
Hi, Naresh. Yeah.
So basically, the IPR, when we talk about IPR in terms of for the salespeople, it is very important to have IPR protected for the company, because if we do not protect the IPR, then there are chances where you can safeguard the licenses, the technology which you are selling to the customer. And if they get the IP rights, then you don't have right to produce additional or further licenses for the same technology.
Yeah, partially correct, Naresh. Anyone else want to? Naresh, if you can mute yourself now. Anyone else want to answer? Yes, it will be great if you have, when you're speaking, you can have your video also on. You have to say something? Okay. Let me see who has raised the hands. Lakshmi, yeah, you want to say something?
Yes, according to me, the whole idea of patent or intellectual property right is based on marketing. If you have invented something, and it needs to have marketing. Unless there is no use, like Russia has created COVID vaccine. Unless they don't have proper marketing for that vaccine, there is the patent or that that invention doesn't make sense unless there is good marketing there.
Okay. Yeah, so basically marketing and sales people require support of an IPR because finally they need to tell the people, look, this is protected, right? In fact, many of the marketing people, you must have seen, this product is protected by 500 patents, they will say. This product is trademark, no one else can use it. So all these kind of ideas, all these kind of advantages the marketing and sales people get at the ground level is amazing. It's they are more interested whether our product is trademarked or not. They are more interested whether the product is patented or not, because they will put it on in their marketing brochure. Okay, we have 500 patents around this product. I don't know if many people know about Amity. Amity would come out and say they will say that they file so many patents per year. So why will they say it? It's kind of IPR helps them in marketing also. So perhaps this is very important for marketing and sales people to know about IPRs. And let me also ask you one more question. Why are the CAs, chartered accountants, interested in IPRs? Can anyone take a guess? They are interested in balance sheets. They are interested in why would they like to know about IPRs? Any guesses? You can again raise hands if anyone has any answer. Okay, yeah, this is much better. Okay, chartered accountants basically they have to value intangibles, and I will show in my subsequent slides that most of the valuation of a company is nowadays intangibles in form of IPRs. So a chartered accountant, in order to do valuation, in order to do audit, would like to know what kind of IPRs we have, what is the value of that, and especially is a merger and acquisition taking place, we need to have chartered accountants value your IPRs. So again, this kind of the IPRs as a subject is very important for chartered. I'll go back to my slides again, and I'll try to show you where we were in terms of having career in IPRs. IPR is touched by mostly all the domains and all the subjects. Okay, let me again go to my slides here and share my screen. Human resource, of course, the human resource department, because they want everything that has been created by employees remain with the organization. So human resource department is again very much impacted by the IPRs that the company hold. Okay, let me go to the second slide. Okay. This is careers in IPRs for law student, but it's not only for law student, it is for all streams as I was discussing. You can become a litigator, you can become prosecutor, you can become manager of IPRs, you can do auditing, especially important for chartered accountants, brand protection in terms of anti-piracy action, and we'll talk some of these roles and responsibilities subsequently. Mergers and acquisition, as I said, one of the very important component in mergers and acquisition of IPRs. Remain as you can become a patent prosecutor, you can become a litigator again, portfolio manager, patent drafting. Many people would be, I know here are from engineering background and they would like to draft patent application, draft claims in a patent application. I don't know how many of you have seen the patent application, but it's a document. It's a legal-technical document where there is a lot of legal language being used as well as engineering language is used. So if you get a chance, you can go to Google, search for some patent, and actually see some of the patent applications that are there, and try to see how they are divided into prior art, description, and the claims part of it. And we shall cover it a little bit as we go forward in our presentation. licensing and contracts manager, very, very important, especially for startup companies. Me and Sujata, like a week back, we were discussing something with respect to startups, and their whole game globally was to have licenses and licensing and contracts, different kind of licensing that we were discussing, whether it's going to be on cloud, on premise, SaaS based. So these are different kind of licensing and contracts, which again are IPR based, and that leads into a lot of career opportunities for IPRs professionals. Patent trolls, again, these are something, it's a negative word. As you know, trolls is negative, but there are companies which actually buy patent and then sue big companies and make money out of it. There are some of them in Bangalore, I know, very specialized kind of a patent troll. It's again negative, but their whole role is to buy patent application, purchase them, and see which big company is using them, and then exactly buy it at a cheap rate and get good compensation and damages out of the patent. Open source and standard negotiations, again a very complex part of IPRs. Some of the lawyers are very, very specialized in open source, and I can quickly define you what an open source is. Open source is a kind of a license which is given, which is open for everyone to use. Okay, it's not by a company. For example, the Microsoft operating system license is by Microsoft, but there is an open source movement which says that, okay, software is free and people should be able to use it free. And they have come out with several open source programs, modules, and software parts where you can use, plug and play with those open source components and actually use them in your program. Of course, you don't have to pay any fees because these are open source programs. And one of the example, I don't know, many of you are students here, so you would know SWAM, which is a Government of India initiative, which is kind of an open academy, which is again an open source. Student can go enroll and do a course from there. So again, open source requires a lot of licensing conditions. As a career for IPRs professional again. So these are some of the things that you can do being an IPR professional. For myself, I just see myself as a litigator, IPR litigator in the court itself when I go and enforce IPR rights, and which is the last section we will go in more detail. But I have done several part of whatever is mentioned in these slides over the last 2 decades, including open source and in mergers and acquisition. So of course, if you have any questions with respect to that, I'll be happy to answer from my own experience myself. Okay, all right. I will move on to the next slide, which is the definition of intellectual property rights. It's a little older slide, but remains the same. The definition remains the same. Anything that is created by virtue of your mind. Okay, so it's a creation of mind. It can be in any form, and we'll discuss different forms of IPRs, but it can be in any form, whether it's a patent, trademark, copyrights, designs, trade secrets, any kind of thought that you might have in terms of that saves your time, that saves your cost, that saves your energy, is a subject matter of an IPR. The example that
Sorry to interrupt you. There is some bar on the screen which is making it not visible.
All right. Has it gone now?
Yeah. Thanks.
Okay. Sorry about that. So this is we have So if we see, in modern corporation, we see this is slightly older figures, but I can say today's 90% of the assets of a company are in the form of IPRs. Okay. So for example, big companies like Microsoft and Google, kind of valuation. They may hold buildings, and they may hold furniture, and they may own you know, whatever tangible assets in terms of assets, but that will hardly be 10% now. Okay, 90% is IPRs. So their whole book value. Why is it IPRs? Is because Google is not that they own a building in Gurgaon, complete building in Gurgaon and Hyderabad, and this is very small thing for them. What Google owns is an algorithm which takes you to different servers, so that whatever keywords that you put in there, they get you the relevant data on that. Okay, so if you write today in IALM, it should get you the relevant data on that. If you write Dinesh Jotwani, it should get you a relevant data on that. And because of the algorithm, which is probably trade secret or patented, that kind of an intellectual property that they own is much more valuable than anything else, anything assets that Google may hold. So what this chart is trying to tell you is the value of IPRs vis-a-vis the value of physical assets that a company may own is diminishing year by year and decade by decade. So as was mentioned, intellectual property is creation of mind. The simplest example that I talk about to the students is if I know my way to, if I know a shortcut to reach my home early and I don't share it, that's also my intellectual property rights. I'm not telling that to anyone. I may know a way where there are less traffic lights, where there's less traffic, and I can reach, instead of 20 minutes, I can reach in 5 minutes, but I haven't told my colleagues about it. So I own that kind of intellectual property rights. In a simplest form is something which is a mixture of creation of minds as well as the implementation part of it. All right. So broadly, this is what intellectual property rights mean, and we will go ahead and talk about different forms of intellectual property rights which get protected. I just don't know why my slide doesn't move. I have to leave the full screen mode and then perhaps to, yes, now it moves. All right. As you know, the topic today was IPR protection, enforcement, and business strategy. I thought I will put the business strategy part before going into IPR's protection and enforcement part, because it's important for you to know what is a high-level strategy to protect IPR. Why are we doing all this? What is the reason that we give so much importance to IPRs? I told you in a slide earlier the kind of intangible assets versus tangible assets that a company owns. But let's look at what is a high-level strategy. High-level strategy that we need to justify investments in research and development. For example, nowadays everyone would know the COVID situation. So there's millions and billions of dollars going into research, into developing COVID vaccine. It's a human crisis. The companies that are doing it at this moment would like to protect their IPRs. They would like that when they have invested so many, billions of dollars, they should get some revenue out of it. Though it's not a perfect example, because at the end of the day, this is a human crisis, and I personally believe that these companies should give these vaccination and the formula to this free of cost to save humanity. But at the same time, their logic is that they have invested so much money now, and they would like to have certain returns back, so that the vaccination which they have developed should give them some rewards also. So this protecting an IPR justifies an investment in research and development. It creates a freedom of space to work around. Once I create an invention, I come out with a brand name, it gives me space to work around that. So I'm from a software background also, apart from being a lawyer. And I can say, for example, a company comes out with say a unique kind of security system, and it implements that, but he doesn't want that tomorrow some other company comes in and develops that kind of a signature or module. So it would like to patent it, so that at least in that particular area it gets a freedom of space. In that security space, it gets some freedom of space where it can develop further, where it can innovate further. If somebody comes with a security module which is entirely different, they can do it, but at least not the one that I have invented first and I have put in my research and development into that. It gives me a competition edge in the market. It can be used for defensive and cross licensing purposes, and we'll cover that when we come into part of it. It creates a brand and product awareness about the group. When you sell your product, you know that this product you trust. So in a way that it creates an awareness in the market itself, and it's a name that is associated, that gets protected under the intellectual property rights law. And Sujata will be covering about the trademark soon, and so you will know how important it is for a company to protect its mark. And again, you protect. Yeah, and finally, you need to protect yourself from hackers and pirates. So that's an important role of intellectual property rights. What happens if you develop a software and tomorrow somebody cracks it and just sells it for free in the market? If you go to Nehru Place, I don't know how many of you are from Delhi, but if you go to Nehru Place, you all find all the pirated software being sold for 50 rupees and 100 rupees. The actual cost of that may exceed more than lakhs of rupees. So how do you manage that kind of a situation? Is protecting through copyrights, right? You develop a movie worth crores and crores of rupees, and you find that that's being pirated, that's being easily available, and the producer loses all his revenue out of that. So in order to protect the movies, you go ahead and you copyright yourself, so that no one is able to infringe upon what you have produced or whatever you have developed. So this is a high level strategy for companies to protect IPRs. In fact, IPRs, I will say, are the first kind of lawyers that the entrepreneurs, that the companies would contact the moment they have new ideas, the moment they want to invest into R&D. The moment they have something unique offering that they want to do, the moment they think of coming out with a movie, and the moment they come out with a movie name, they will like to trademark it. The moment the movie gets produced, they will copyright it. So I would say they would approach a normal litigation lawyers much later on. First, they would like to approach an IPR lawyer or an IPR professional before taking on any of their business ventures. In fact, that's why the IPR professionals are very relevant and very important for startups environment. In fact, startups, if you see, they want to protect their IPRs, and then finally they go for funding. It's not the other way around. People think that once there is a funding, they will once there is a funding, they will protect IPRs. In fact, it's just the opposite way. Once they protect their IPRs, once they come out with a new idea, that they go ahead and then they get the funding. They look for a funding on this. So this is something high level strategy from very small businesses to the largest businesses that you can think of. If you think of a smallest business is what? Your grocery store, your restaurant are very small. They need an IPR person because they need to protect their trademark. So I was 2 weeks back, I was in the evening taking a walk, and I saw this board which was Kalu Ka Dhaba, and it was written registered. So he has got this Kalu Ka Dhaba registered mark. Why is he doing that? He's a very small player, and he's still going on and he's registering his trademark. So he needs an IPR person. From that to the McDonald's, which is the highest kind of a restaurant or a chain of multinational restaurants that they have come out. So they need thousands of marks. McDonald's is not one trademark. McDonald's is lakhs and lakhs of trademarks. Each dish that they come out with, say Mahaburger, they come out with any new fillet of fish burger, any dish they come out with, they will go ahead and trademark it. And they will go ahead and trademark not in one country, but all 160 countries, they will go ahead and trademark it. So you understand the importance of trademarks now. It's not from a small restaurant to the bigger one. There is an IPR strategy, there is a business strategy to consult an IPR lawyer, and finally to align their business that they get most out of it. And in fact, I would say many of the Indian companies require this kind of an education in terms of when they come out, when they start something, how they can protect their uniqueness, their strategy in form of IPRs. All right, let me stop here a bit and see if I can see any questions or anyone has raised any hands on the strategy part of it. This is what we are trying to talk now is about the strategy, IPR strategy. Okay, no questions? Let's move forward. Okay, I'll share my screen again and see where we can. All right. I'm facing some problem in slide moving, but let's see. Yes. Okay. Intellectual property overview, and these are some of the statutes which protect IPRs in India, and as I mentioned, these are some of the IPR statutes. These are not all of it. This is not an exhaustive list, but I can quickly tell you. Patent Act, of course, Patent and Trademark Act respectively protect patents and trademarks. There is also a Design Registration Act. Many countries don't call it a design, they call it patent itself. So a design is registered under a Patent Act in many countries. So don't get confused when they talk about patents, but they are actually referring to the designs. There is a Copyright Act, geographic indication of goods. GI is again a very, very important part, and actually protect goods coming out of certain origin. For example, Pashmina shawls or Kolhapuri chappals. They are come out of a place called Kolhapur. So, and Pashmina comes from Kashmir. So no one else can, actually name them as Pashmina shawls. Or, for example, whiskey from Scotland is Scotch. You cannot have Scotch made in Uttar Pradesh or Maharashtra. It won't be called Scotch because there is a geographical indication protection on the goods coming out of certain region. And this is again a very important act. Protection of plant varieties and farmers' right, again a very, very important statute. And there has been a litigation in India on this. When a farmer regrows its seeds, does it need to pay royalty to companies like Monsanto, where when they come out with new forms of seeds and they give it to the farmers? So this act actually balances the plant varieties. Companies like Monsanto, they come out with plant varieties, and the rights of the farmers on the seeds that are there. So again, a very, very important form of an act, which is now giving rise to lot many disputes and litigations. You would see in Gujarat and Punjab recently, the farmers were against big companies like Pepsi, and the matter, unfortunately, the matters have not concluded yet. So we cannot have those judgments cited as some kind of a precedent, but there is a very interesting litigation going on between farmers and the big companies that own the seeds. So these are some of the important statutes, and if I missed out something, there's probability I might have missed out something. So we can cover that also. All right, so this is an overview of intellectual property rights. Very, very important slide, actually, from patent, trademark, copyright, and trade secret. So let me talk about patents first. Patents, the length of protection is 20 years. It protects functionality, things, how they are made and used. The symbol of patent protection is a patent number so-and-so. And then there are, it focuses, it can be a utility patent and a design patent also. So or a plant patent also. I told you previously that many countries have this in one statute itself, patent and design. In India, it's two different statutes. But yes, patent would protect useful features and useful things. And when you see on a product patent number so-and-so, it actually means that there's a pending patent which is there. In terms of trademark, trademark is actually forever. You can see Coke, which is like from centuries, they have protected their trademarks. And every 10 years, you have to renew it. It is for specific product and specific business. It has to be associated. The trademark needs to be associated with some kind of a good or a service. Its symbol is TM or R if the mark is being used or there's a pending application. You have to write TM. Once it gets registered, then you can write R on the same. So this is kind of a symbol for trademark. And why it is used is for a brand protection in terms of counterfeits that are available, of piracy that is happening. Very, very important to protect your brand, and that's how the trademark is being used. Copyrights are the life of the author. So if I write a book, that gets protected in terms of my life completely till I live. And plus in India it's 60 years, but it can range from 50 to 75 years depending on the country. So I am not sure. I think India is 60 years or 75 years. So after the death of the author, your copyrights get protected for so many years. In case of a company, when company creates some work, for example, company creates some software which is subject matter of a copyright, it gets protected for 120 years. It protects printed or recorded materials also. Copyright symbol is C. You must have seen in most of the work, there is a C written. In fact, in slides also, we write C just so that it's protected by IALM. Its registration is used for anti-piracy action, and we'll talk about it later on. When the software gets pirated, when the software gets sold without authorization, there's an anti-piracy action that you can action against the respondents. Then trade secrets are forever. For example, the Coke formula is forever. They have protected it. There is a big, huge safe in Atlanta, and I visited that place. That is a huge safe where you have kept the Coke's formula. Nobody in the world knows how the Coke is produced. Okay, what is a chemical recipe for Coke? No one knows it. They may have given license for bottling and everything, but not for um, not the chemical formula for the Coke. So that's the best kept secret over centuries that I can give an example for. And it protects, and many companies have many kind of secrets. As I said, Google has secret on its algorithm on how it gives you such a good results. When you type something keywords, it gives you such a good results. Why other companies have failed? Why have Yahoo failed? Why have Bing failed? Bing is Microsoft. Nobody uses Bing, but why people use Google? It's not that it's they have patented that algorithm. They have made it a straight secret so that no one is able to know that algorithm, why it gives result. Okay. Trade secret is, there is no statute, as you remember from my last slide, there was no statute. So trade secret in India, there is no statute, but if you go outside India, yes, there is an act, there is a legislative act that protects trade secrets also. So there is no no act or no symbol for a trade secret. It protects things, it protects which may not be patentable, or it may be detectable. So it will protect those kind of things that you can keep as a trade secret. In fact, I'm a very much proponent of trade secret as an IPRs. And in fact, there is also a legislation pending with Indian government where they want to bring in Trade Secret Act, which is not there in India so far. So in India, we need to protect your trade secret through contracts rather than through a legislative action. So these are different forms of IPRs that we will be talking about today, and we'll go in a little detail on each of these forms of intellectual property rights. Okay, let me go to next slide, and it's going to take a few seconds before I switch to the new slide. Okay, since I was unable to change my slides, so I will just, I'm sharing screen with the normal mode, not with the full screen mode. I hope you're able to see the slides, still able to see the slides. And in terms of importance of IPRs, I'll be very quick and tell you about how different companies use IPRs to their strategic advantage. In terms of IT, information technology and information technology enabled services industry, they use patents to protect new features, processes that they have developed. For example, I can take the example of Infosys, which has several patents regarding financial services and financial transactions, how it takes place. So they have protected their software and the features through patents. They have also used trademarks to distinguish their services and products from competitors. Okay, in fact, Many applications, if you see, of Infosys are pending at USPTO in India in respect of new features that they come out while developing new products for their clients. Software publishers, copyright owners like Microsoft, Symantec, Adobe, these are they own a lot of patents in terms of new features. For example, Microsoft has so many software products. Operating system, of course, they are known because of their operating system Windows, and each of the window new feature that comes out gets protected by a patent. So each year Microsoft, on their operating system itself, they will file more than 10 to 15,000 patents all over the world to protect their new features. Of course, copyrights, because it's the software, the code, the source code that they write, again gets protected in terms of copyright. So very important form, IPRs is very important for software publishers, big companies like Microsoft, Symantec, Google, Cisco. All these companies are also software. Cisco is known as a hardware company, but they have a lot of software patents that get embedded into their hardware. So very important for software companies to have IPRs. Going to the next slide. Automobile industry, of course, very important in terms of design patents, or designs, you can say. Designs are nothing but a look and feel of the part of the automobile. So why Mercedes looks like a Mercedes and nobody else can make that is because it is protected by way of 340 designs registration. So one car, the way the mirror is, the way the logo is displayed, the way the window is, or the way the shape is, the bonnet is, the door is, the lights are, the way it looks gets protected by way a car can have 350 designs. Each model of them can have these many design registrations, and imagine so many models are there, and so many companies are there, and then so many countries are there to protect. So you can imagine the kind of designs that are so important for an automobile industry to protect in so many countries and in so many ways. Then restaurant industry, we just talked about it briefly. Why is it important for a small restaurant to protect their trademarks? Because each dish in McDonald's or KFC get protected by way of trademark. And also trade secrets. You know, why we get addicted to KFC chicken pieces, because they have certain, the way they cook or the kind of oil they use, because it's their trade secret. Even their franchisee who will not know what exactly is there in the ingredient to be trade secrets. Okay, there's an estimated on McDonald's trademark value to be more than $21 billion. It's just the value of the trademark. Can you believe it? India doesn't have hardly any company. You can count them on fingertips, which will have more than a revenue of more than $1 billion. Here we have only one McDonald's trademark, which is worth more than 21 billion. So that's the power of intellectual property rights. Okay. We go to pharmaceutical companies, very, very important for them to protect their new formulations. In fact, if they come out with a new molecule today, it will take them 10 to 15 years to get that molecule in the market because of the regulatory, the environment in pharmaceutical industry. They need to have clinical tests. They need to have FDA approvals. Each molecule of a medicine that they develop, they may be spending around $800 million. And what happens if there was no intellectual property rights for companies like Pfizer and Novartis and Ranbaxy? They come out with these medicines and new molecule, which are helping humanity curb these diseases. Uh, so, and it is taking them 15 years before they bring the molecule into the market. So only when the patent is important. So that's why the patents are very, very important for pharmaceutical companies to in order to protect their investment in research and development that they do over so many years. Trademark is also very important for pharmaceutical company. I don't know how many of you are following this dispute of Coronil, which is named by Patanjali, and there is also a Chennai-based company, and their dispute has gone to even Supreme Court right now on the basis of coronavirus, um, medicine that Patanjali has just developed. So Coronil existed long back and a registered mark, whereas Patanjali has just named it. So there are some interesting questions of law that are going on in the court of law. So the point I want to bring is very, very important for pharmaceutical companies to give importance to trademarks as well. Lastly, I will say very important for electronic, print media and film industry to have copyrights, because all their works, if I write a book, it will be protected by way of copyrights. It will be protected by so film, print media, electronic, all these kind of things bank very, very heavily on copyrights. Even if you see a small presentation or a paper that gets produced has written copyright on that. Now there is a whole registration process for copyrights that the companies needs to follow, but I think this is the biggest filing out of patent and trademark is with respect to copyrights, because if copyrights were not there, the movies will get pirated, the songs will get pirated, the software will get pirated, and books will become pirated and counterfeited. So what is the remedy? The remedy is to have your protection under copyright law. Okay, let me see if there is anything I can. All right, any questions so far? Okay. All right, we'll move on to the next slide. Okay, we talked about, in our previous slides, we talked about patent, trademark, copyrights, and trade secrets as being important forms of IPRs. This slide actually talks about, it just gives an example of Apple iPhone. Let me show you. Okay. One Apple iPhone is protected by several patents, of course, new features, functionality that it gets in. Or BlackBerry, it's a BlackBerry. You can give an example of BlackBerry also, where it gets protected by way of the features, the enhancement, the APIs, and business method processes. Then you have copyrights again in terms of source code, technical papers, database, data sheets, videotapes, all that marketing material also in a phone that gets by way of copyrights. And of course, the source code, which is a software that runs in the iPhone. Of course, trademarks, Apple iPhone or the BlackBerry itself is a trademark. So you have a lot of importance of iPhone itself, which is part of the trademark. So all the product name, feature name, business names, slogans, logos, colors, smells, and sound. And Sujata will cover more detail into this part. So one phone will also be having trademarks. Then, of course, a lot of trade secret, as I said, the encryption that takes place, the business processes, the source code, manufacturing technique, sales information, legal, HR, finance, customer list, all that is an example of trade secrets in one telephone itself. Then there is a third party code, which is again a form of intellectual property rights. Apart from patent, trademark, copyright, trade secret that I told you, there is something called a third party intellectual property rights, which we were talking about earlier, which is not owned by Apple or which is not owned by a company, but it licenses it out inside. And that is a substantial kind of a component in any big company, because it's not necessary that the Apple actually have everything that belongs, patent, trademark belongs to it. It may try to buy certain technology, or it may import certain technology, or open source itself. I was telling you about open. So it may use its open source from a third party, which does not belong to that company, that does not belong to Apple. So there is a huge component of third party IP, intellectual property rights, in the products that come out, the products that we see day to day. Okay, so this is kind of one example of an Apple iPhone, which will have patents, trademarks, trade secret. In fact, somebody was saying that one Apple iPhone has around 200,000 patents. There's no way to know that, but yes, if that is a rough estimate, then you can imagine one small product itself has so many patents into it. I don't know how many of you have used the Uber or the Ola cabs. It's a very small module on your phone, but they own like 100,000s of patents in that small module. The way the geolocation takes place and the way you can contact the driver, the way maybe the OTP is given to the driver. So they may have 100,000 patents. One small Uber module may have not only copyrights in terms of software protection, but also in terms of patents. It has thousands and thousands of patents into one module that is there. Okay. All right. So this was bit introduction. Let me quickly take you through. Let me take you through this on patents. What we will do, we'll talk about patents, trademark, copyright in little more detail, and see if you can make use of it in your in your day-to-day activities, and of course if you can see the importance of it in products. So what is a patent? Patent is something monopoly right that you get. Okay, so if I develop a COVID vaccine now, after investing millions of dollars, I get a monopoly right. So this becomes my property, right? And it's the same kind of a property as my house. So what happens if I own a house in Delhi? Say I own a house in New Delhi. What does the owning a house means? Means I can reconstruct on it. I can use it in any manner. I can license it out. I can rent it out. I can give it to say Ovayo rooms for using it. I can give it to my relatives to use it. I can sell it out. I can offer it. I can import it. So I can actually, through patents, through the ownership of the house, I can do anything that I want from that particular house. Similarly with patents, just to give an example, it gives me, once I own this patent, it will give me right to make it. It will give me right to use it. It will give me right to sell it. And I can sell it not only completely to somebody, I can sell it part-wise. I can sell it say in Maharashtra, I can sell it to one person in my patent, and I can sell it in West Bengal to another person. So it gives me kind of a selling rights. In any manner I can sell it. In one place I can sell it completely. In another case I say, okay, you make it, you, once you get some revenue or royalty out of it, give me 10% of it or 5% of it, the revenue, which is going to be huge because I don't have to do anything. I just have invented it on and got a patent on it, and I can earn the revenue out of it for next 20 years. So this is kind of a patent. Patent is an monopoly that is given to me for a limited period of time. In India, that is 20 years. Okay. And what is an invention? Invention is anything that is new and anything that is useful. Okay. So if you combine these two things, there is a third thing also, but that's a little more complicated. It's called, it has to be non-obvious. Okay. But let's focus on these two kind of parameters in an invention. It has to be new. New means it has never been done anywhere in the world before, right? It's a kind of uh, lot of people, confuse it from jurisdiction perspective. So when they say new, they mean new because my patent is going to be valid in India. So it has to be new in India. No, that's not the fact. From novelty perspective or from the newness perspective, it has to be globally new. If you remember a few years back, we invalidated some of the US patents in terms of basmati, right? How could we do that? We could do that because in India, we've been using basmati from centuries. Okay, how can USPTO grant a patent on that? So we invalidated that patent because though we have no, we are not governed by US laws, but because the definition of patented, it has to be new worldwide. Okay, don't think now from novelty perspective, you cannot say that in India it is new or in US it is new. It has to be new worldwide, and it has to be useful. That's a very small bar. Of course, all inventions are useful. You can argue that the invention of the coronavirus itself, I mean, we're not sure about that, but if coronavirus was an invention, can it be, is it useful or is it not useful? Well, it can be useful in certain way if it is in a controlled atmosphere. So you can perhaps go ahead and patent it, but it is later on found that it is used to destroy so many nations and so many economies. So the word useful in an invention is a very vague term. Even Einstein, when he invented some of the formula for nuclear energy, he said that this is not useful. It can be also used to destroy nations. So again, this is a very low bar, I will say, from patent perspective, that it is new, it has to be useful. The third criteria, not mentioned in my slide, but people who are practicing will come to know, when a patent examiner comes and says it's a non-obvious, it has to be obvious. Obvious, it has to be non-obvious in the sense that you are just not combining two things and making a third thing out of it. You are not combining a tape recorder with the with the camera or with the displayer and saying that this is, I have invented a television out of it. No, it has to be some kind of a granular combination of products. Okay, this is very, whenever I have actually practiced before the they just use it that, oh, it is. So how do you handle that if it is so obvious? That kind of example, you have to show it to the controller and convince what is obvious and non-obvious. But from our invention perspective, anything that is new and useful is an invention. So majority of the patents fall into an improvement type. And by that I mean it is a very, very marginal improvement into the products. Okay, somebody came out with a pen and the other person made a refill. So that is, refill is a kind of new patent. Somebody came and made a kind of a hook on which is on top of the pen. He says this is also very useful. It's a small improvement. Pen was already invented. So somebody came out and made a cap of the nib, okay, so that the ink doesn't fall on your clothes. So that is also kind of a new. If it was invented for the first time, you could have protected by way of a patent. So it's a small improvement that has taken place over the previously known product that the patent is a subject matter of. Okay, so this is what an invention is, and lawyers would like to protect that. Who is an inventor? The one who has an idea, the one who changes the idea and makes it better, or the one who adds some detail into that basic idea. Okay, so he's an inventor. Don't confuse it with a person who is just implementing a new idea, or who is giving a problem. If I come out with a problem, this is my problem, that's not an invention. So people confuse, okay, I faced this problem for the first time, so I am an inventor. He's not an inventor at that time, because he's just given a problem, or the person who implements or who executes it. So he's again not a inventor. Company who manufactures or who pays for it, again they are not inventor. Inventors are the natural people, okay, and who first came out with an idea to solve a problem. And this inventorship issues and inventorship is kind of a new kind of a disputes that have arisen between and are litigations also, where people say, no, I invented it first, I had an idea first, I paid for it. So what if you paid to your software developer develop a website, and he comes out with some new idea in the website where it's kind of a portal where you can have marriage matchmaking in a unique way, and he says, I developed this. So he's not an inventor. You gave that idea to him to develop the portal in certain way so that the matchmaking between the couples become easier, right, or more effective. So you came out with that idea, and you are an inventor in that case. It's not that your developer or the person who has made the portal. So if you decide to file that as a patent, you are the inventor, not the developer cannot go ahead and file a patent. So there are a lot of inventorship issues that come up in an IPR lawyer's profession, and these are some of the basic things that they need to take care of while deciding on the inventorship issues. All right, so this is some basic things about patents, and now we'll talk about trademarks, and I'll hand over to Sujata. But before that, let me see if there are any questions so far. Let me try to read the chat and see if there are any questions so far. Okay. Yatin Gupta had mentioned, how is an IPR valued? Okay. Yeah, so IPR valuation, again, I started with this, mostly done by chartered accountants, but there are 2 or 3 methods you could do it. One method is cost method. So suppose you came out with a new pharmaceutical formulation, and you spend $800 million into total making that molecule. You will say, okay, I can sell it for, say, double the price, or maybe let me have 50% benefit. So that's a cost-based valuation of an IPR. Then is a market-based valuation. How much will it be if I sell it in the market? That's, suppose you own a house, how will you know the market value of your house um, is by actually looking at the deals around your home. Okay, so my neighbor who is just 4 houses away, he was able to sell his house for 50 lakh rupees. So mine is better placed, and a corner one I will value it at 70 lakh rupees. But unfortunately, the market-based valuation of IPR is not possible in uh, in the um, in this scenario, because patents are something which are new, and you don't have an example of it. Whereas in a house, you can see an example of your similar property, but in a patent, you don't have a similar, because by definition, patents are something new. So market-based approach is very, very difficult in getting an IPR value, especially patents. Uh, Secondly, there is a third way to value IPRs is the discounted value, and many of you who would come from mathematical background would know that, and especially the how you value your insurance, or how you put a premium to your insurance, or how do you calculate interest. So if you have a patent for next 20 years, and this is what the current revenue from the patent is coming, so you discount that over 20 years, and you see in 20 years I will be able to earn $500 million out of it. So out of that, okay, but today for me $150 is okay. Let me not wait till next 20 years. So the discounted value is $150 million out of it. So that's another kind of a way to value your IPRs. So that's there are three ways. I mean, we can go in. There can be a whole lecture on valuation of IPRs, but let's confine ourselves right now to the main introduction part of it. Next, I think Lakshmi, you want to speak something? Yeah, let's. Why don't you unmute yourself and ask question?
Hi, sir. Yeah, when I was doing this patent act initially, I have this doubt that when one inventor files an application, his invention is published only when the patent is granted. Meanwhile, he is investing so much time and money for the processing of the application. Let's say, meanwhile, another person also, there is someone else also who filed the same application, but prior to him. So how will he get to know that there is some same patent running, same application is running along with him? Like, he doesn't have to invest so much money and time for that. Like, I really have a doubt in this.
Yeah, that's kind of a tricky question. What happens is when you file a patent application, it gets published in 18 months. Usually, it gets published in 18 months. Whether it is granted or not granted, that's a separate thing. It may take even 3 years or 4 years to get it completely granted, but the process is it has to be published in 18 months. So there is something when I file a patent application, I do a prior art search and see if there are any pending ideas or pending patent applications similar to my kind of an application. There is a very easy way to do it, and patent search they call it, or they call it a prior art search, where you can actually look at the patent, look at the technology, and easily look at the classification. Each patent is classified, and look at those classes and see if there's something of similar pending or not. There is a risk of 18 months, of course. So if I have given an opinion, I can give opinion as of today. Okay, but if somebody is filed only 2 months back, which is a less chance, and there is, as a legal person, you give a lot of disclaimers also when you give a report. So suppose I give a report saying, oh, everything is clear, but only 2 months back somebody had filed a similar kind of an application or an idea, then of course I will lose. That's a risk of, I think, 18 months that person has to take. But my experience says it doesn't happen. Practically, it doesn't happen. There is, if you give an honest, work hard and look at some of the databases, look at the prior art, you will be able to know whether, because many of these inventions take years and years and decades. So 18 months of difference, or the blind zone, I will say the blind zone of 18 months, you can take that risk and still file it. And if there is somebody who would file like a month back or a 2 month back, that's a bad luck. I'll say it's just a bad luck that happened. But don't be worried, this doesn't happen. This normally doesn't happen. If your client has not cheated, if he has copied someone, then it's a different thing. But if he is developed on his own, most probably it is going to happen that it is going to be a new patent on that. Does that answer your question, Lakshmi?
Yes, sir, sure. Sir, I had one more question.
Sure.
Yeah. So in this PCT application, if I don't file a proper application for India, for like a patent specially being granted for India, I just file a plain international application. Would that application be considered for a patent in India also, or I have to file separately?
No, it will be considered for India. In fact, when you file a PCT application, in the application itself, you have to mark the countries where you want your application to be examined. So at that time, you should choose India as a country. So what you're saying is my first application itself is a PCT application. For the people who do not know what is a PCT application, there are applications, that international applications that you can file. It's a under patent cooperation treaty, and they will be examined. It takes around 30 months for them to arrive in a national phase. It offers certain advantages. So basically, Lakshmi, to answer your question, yes, you should mark it for India also, so that it comes back after national examination. It comes back to India itself.
Okay, sir. Thank you.
I was finishing with this patent section. Anyone else with anything else? Any other question? Let me see on the chat. Okay, I don't see anything. All right, then let's move on. I will request Sujata. Sujata, you're there. You can have your video also on. We will we'll go on to the next session, which is trademarks. Let me share the screen. Give me a moment. I'll just share the screen. Okay, so perhaps you can now start.
Yeah. Am I audible? You can hear me? Am I audible?
Yes, Sujata. Very much. Go ahead.
Okay. So hi everybody. So I think I've already been introduced in the beginning itself. Like I'm into I was introduced. I am into IPR for the past 20 years, and I've been doing a lot of litigation and prosecution and consulting and all that. Now we will take up trademarks. Initially we will see what a trademark is. Can we have this bar off, Dinesh? Dinesh?
Is it gone?
There's one at the bottom. Yeah. Let's look at the definition of a trademark. Can we go back to the previous slide, please? So, trademark is basically, it's you can say a device which is used by any organization or individual or any legal entity to identify the source of its products and services. And the basic thing is to distinguish it from the products of other competitors in the market or other people. So you have various kinds of trademarks. So like some of them are words, they could be figures, or it could be a combination of words and figures and numbers or numerals. Anything that has a very distinctive feature, that is called a trademark. So, and what's the purpose of trademark law is to have, always denotes that this product, it's coming from this house. Like if it's say for example, something from Godrej. So, this is a good product because over the years, Godrej has built a reputation for itself. So I can safely buy, if it's a new, say Godrej is launching a new product, then you may buy it saying that, oh, it's coming from this place, this company. So it has certain quality, and they definitely conform to certain standards. So I can buy this. So this kind of confidence it gives to the customers. So this is also one of the purpose of the trademark law, to have confidence in the accuracy of labels. And basically it gives you the origin of the goods, from where they originate, who is the manufacturer of the goods, and what kind of a reputation it has, and what is the quality that is being offered. So this is the main purpose of the trademark, to build the trust in the eyes of the customer. Next slide. Can we go to the next slide, please?
Okay.
Yeah. So there are different kinds of trademarks. What is a word mark? This is the most common type of trademark, is the word mark. So word mark could be anything from a single letter, or it could be a combination of numbers, like you have 786, 555, all these things. Or these are examples of a few word marks, like Microsoft, KFC, Apple. All these things are word marks. And then even slogans, they can be trademarks, like life is our life's work, just do it. All these are can be trademarked. uh, then you have design marks like this, like you have the McDonald's, the Coca-Cola, and all. Some typical, when you see this M there, you immediately you identify it with McDonald's, right? So and these are some of the examples which you can see here. Next slide, please. So like, as I explained before, these are the basic functions of a trademark. One is to identify the goods and their origin, from which, who is manufacturer of the goods and all that. And a trademark, it gives you a consistent quality, like, so and the mark, it serves as a guarantee of the quality of the goods. Then obviously, if you don't have a brand, you cannot market it also. So it is a very big, till you have a brand name, for till your products have a name, you can't market it. So it is a very big, very good marketing and advertising device. And also in the consumers. So like if you want to buy the same product, you bought a product. If it doesn't have a brand name, next time you obviously can't go to the shop and you can't tell them, give me the same product till you know till, and it also creates an image, the product, so in the minds of the consumer. So these are the main functions of having a trademark for any business, right? Next. So what are the essential features of a trademark? Is this the next slide? Okay, apart from that, there are some other non-traditional trademarks. Apart from the word marks, we have other kinds of marks also. Can we go to that slide, please? These are the non-traditional trademarks. Recently, I mean, the past 10 years or maybe people have started trademarking these kind of marks also. These are the colored trademarks. They have been protected also in high courts and all that. So some of them are the colored trademarks, like you have seen the Cadbury wrapper, it has got a distinctive purple color. So that's the color trademark. And this parachute, it's got a blue colored bottle, which is very distinctive. The moment you see the bottle, you identify it with parachute. So, and then you have sound trademarks, like you have the Airtel music and all that. When you, or the Apple ringtone, the moment it rings, you know it's an Apple phone which is ringing. And then you have shape trademarks. See, like the Ferrero Rocher chocolates, or the Pepsi or the Coke bottle. So these all have a distinctive, unique shape. So that's a shape trademark. And apart from that, you have the domain names. So domain is also considered a part of the trademark. The trademark could be protected as a domain name also. And then smells, like some particular fragrances. When you smell it, you identify, okay, this person is using this perfume, maybe, it's a very common brand, or a unique smell. So these are the other developments of the trademark, law, which trademarks which can be protected apart from the word marks and the numerals and all that. Next slide. So I wanted to. So this is the next is called the trade dress. So trade dress is the overall look and feel of the product or the business. Like if you go into a McDonald's store, like every time you go in, even if it's in different places, you see the same kind of appear. Some things make you identify this with a certain brand. So these kind of things, like or an Apple store, even generally when they give a franchise to anybody, they stipulate certain kind of conditions that your unit should be having this kind of get up and this kind of identification and all this. It's a kind of dress, trade dress, you can say. And also like a distinctive packing, that can also be part of trade dress. The moment you see a bottle, or the moment you see certain things, you just associate this with a particular brand. So these are called trade dress, and these unique elements, they are also protectable. Yeah. So trademark generally it refers to goods, and there's another kind of mark called service mark. Usually in before this act came, the 1999 act came into force, service marks were not protected. But after this act came into force, service marks. So whoever is providing any kind of service, be it a restaurant business or a tourist or travel, bank, shipping services, insurance, all these businesses, medical services, all these, they are also functioning under some brand name. Like it's a Apollo Hospital, you know, it's a trusted brand, or for, you know, Fortes or whatever. So these brands, they are protected. They are not offering any goods for sale, but mostly they are offering services. So these kind of marks, they are protected under the service marks. You have classes of trademarks in which it's a service class where these kind of services are protected. So examples will be like FedEx, Amazon is also providing services. So all these marks would be under service marks. Right. Next, please. So next we go to how do you acquire trademark rights? So legally, how do you acquire these rights? So main, as far as trademark law is concerned, it's mainly the use of the trademark is very important. Like even if you register a trademark and you don't use it, it's illegal. I mean, over a period of time, if you don't use it, it amounts to trafficking. So main thing which is important is the use of the trademark. So it should be a commercial use. Actually, this is part of law of commerce. It's the trademark is for the business mainly. So this mark should be commercially used. If you're getting a mark registered, eventually it has to be used. So so, and what are the benefits of registering the mark? Even if you don't get the mark, if you're using a trademark, but even if you're not getting it registered, you still have rights. You can use the trademark, but you know, there are certain disadvantages of not getting it registered. So, like you may have to prove that I am the owner of the trademark. You have to get evidence and all that. So, so it's sometimes it becomes very difficult to prove that you adopted the trademark first, and there may be certain somewhere else somebody else has adopted the trademark. So all these problems arise if you don't get a registration. So the advantage of registration is it creates a legal record of your ownership, and when you file the application, and in the court of law, obviously you are on a better footing to protect your rights, and there are specific provisions in law to protect you, and in case of infringement you can claim for damages. So it's able to get a trademark registration, right? So, and what is the duration of a trademark right? So as long as the business is there and it's using the trademark rights continue. So once it has been used in commerce, and as long as it's used, the owner continues to use the trademark, the legal rights can last forever. But as far as the registration is concerned, once you get the trademark registered, it's valid for a period of 10 years. And for every period of 10 years, you need to renew the trademark. So if you want to obviously have the registration. Some trademarks have been in continuous use for hundreds of years, like Dinesh was saying, Coca-Cola, and all these people have been, there is a lot of brands which have been using for hundreds of years. And if they are abandoned, when they are not used for a long time, then they get abandoned. The rights, you know, if it's abandoned, somebody else can pick it up and use after a period of time. If you don't use it, somebody else may adopt that trademark and use it. Next. So the act, as on date, we have this act, Trademarks Act of 1999, and it was brought into force on 15 September 2003. And you have the trademark rules which prescribe, you know, all the rules about the registration and opposition, all the formalities to be done, they come under the trademark rules. So the act, what were the main objectives of the Trademark Act? It was like developing the trading and commercial practices, and having a brand also helps you globally if you want to do business outside India. So having a good brand gives you an advantage. So increasing globalization of trade and industry, and a need to encourage investment flows and transfer of technology, need for simplification and harmonization of trademark management systems, and to give effect to important judicial decisions. These were the objectives when the new Trademark Act was passed in 2003. So they wanted to do all these things through the act. Next.
So if I can just quickly mention that after this, there has been India's accession to Madrid Protocol, which has it is also like a common filing system, like Lakshmi was mentioning about PCT. Is a filing system where you can file a kind of an international application that gets examined internationally, but again you have to go local countries and file it. Similarly, for trademarks, there is a Madrid Protocol that India got it implemented much after 1999, but it is again kind of a good way where international applications are being filed in India. This Madrid Protocol cell right now is in Mumbai. They examine all the trademark applications that are internationally filed. So and the rules they are also governed by our Indian Trademark Act and Indian trademark rules. But at the end of the day, many international applications are following that route to get mark registered in India, apart from our Indian Trademark Act. I'll move on to the next slide, Sujata.
Yeah, please.
Yeah. Oh, there is another trademark. Okay.
I think this. Is it this one after that?
Yeah, I think this is. Did you cover this? I'm not sure.
Just go to previous.
Yeah, this is previous.
I've not done this.
Okay. All right, you can talk about this.
So, like we were seeing, what the act, what were the amendments, what the objective was. So then they also provided for registration of services, and then well-known mark. If a mark is well-known, like say a mark like Harvard, or a mark like Haldiram, or everybody knows about it. So these marks, even in other classes to be registered, people, so they are protected specially. So that act also defines what's a well-known mark, and provides certain, there are provisions where you can move an application if your trademark has got distinctiveness over a period of time, and people, when you just say a trademark, they just associate this trademark with the products and all that. So it comes under a well-known mark, and you can get it protected so that others can't use it just like that. And then they wanted to simplify the procedure for all these things. So that is the objective of the Trademark Act. Next. So and so there are certain marks which are owned by associations. So these are called collective marks. So the act provides for protection of such collective marks. And like Dinesh was mentioning, for international applications, you have the Madrid Protocol. So there are provisions in the act for the facilitation of international applications. And if there is a decision of the registrar, if he's not allowing your registration and all, or there are some disputes, then you have an appellate board. for the disposal of these kind of applications and appeals and all that. So and then trafficking in trademarks, if it's happening, so it provides for that, provides for punishment of offenses relating to trafficking, like you're falsifying, you're using somebody else's mark, and or you're getting a mark registered and not using it at all, or manufacturing spurious goods under somebody else's mark. So these are all the criminal offenses. So the act provides for punishment, and what are the recourse you can have for all these things. So so previously the renewal, you could renew a trademark only for 7 years. Now it is for 10 years you have a registration. And yeah, next slide. So, now let's talk about the registration process. How do you get a trademark registered? So, first step is, which is advised, is to conduct a trademark search, because we don't want to, even before adopting a brand, in a particular class, you would first like to know that if somebody is already using this market. You adopt a brand, then you spend a lot of money in marketing your goods under that brand, and before then you realize that there is a similar mark, or somebody else is already using it, so then two things will happen. If that's the case, then one thing is, he will once you adopt it, he's going to sue you for using the brand. So that kind of threat is always there. And secondly, your brand will also not be able to get any kind of distinctiveness, and it won't be able to register also, because later down the line, when you go for registration and the registrar sees your application, if there's a pending, if there's already a registered trademark, he will not accept the application. So it will be a waste of time and money. So the first step would be to undergo a search of whatever brand you want to register, or use in your business. So it is advisable to go for a search. So and determining how also you should take advice on how strong the mark is, whether it would satisfy the basic principles of trademark law, whether it's a good brand, and also how unique it is, whether anybody else has not adopted it, or whether anybody is using it. All these things have to be evaluated if for a business, before you adopt a brand. So the first step is search, and then after, so like I said, if we don't do the search, there is a risk of being sued for infringement, for rejection, and also anybody challenging the application. So, and where will the application be filed? It will be filed as in the intellectual property office. The trademark office, IP office has all the units, the patent, trademark, design, all the units, and it is called the Baudik Sampada Bhavan, and it has got 5 separate offices for each zone. Next slide. Next slide. So these zones are are divided according to the jurisdiction. So Mumbai is the head office. So jurisdiction will be state of Maharashtra, Madhya Pradesh, Chhattisgarh, Goa, and the Delhi trademark office in Kashmir, Punjab, Haryana, Uttar Pradesh, and so on. So these states, they will have to file in their respective trademark offices. So we have to check under which jurisdiction this particular applicant, where his business is located or where he is located. He has to move the application at that particular office. Next. So the registrar of trademarks, they maintain a register, which is a public record, of all the registrations, and it's available online. You can do the search. It's freely available, and you can access, if you know a particular application number, or if you want to search whether a mark is pending, similar application is pending, or registration is pending, it can be checked through the trademark registry website. So, and the context, the trademark, each entry will have everything, the address and description of the proprietors, what class of goods it's registered and what kind of goods, and whether any assignments have been done, and how long the certificate is valid, and when is the due date for renewal. All these things will be mentioned on those records. So, and so this is maintained in all the offices, also in the particular branches wherever the application has been filed. So these records are maintained there also. Next. So, and as far as the registration, you have to specify the particular trademark which you want to get it registered. And also, if you want, if you're claiming trademark in colors, so you have to give the description of the colors, and that I wish to claim certain colors. Like, so if it's a three-dimensional trademark that you want to claim, you have to specifically claim the protection in a three-dimensional form. So, so in India also, you have a provision where through one application you can file in several classes. Like if your trademark if you're dealing in goods falling in different classes, so through one application you can file the same trademark for covering all the classes. That's possible. Next. So, and this is the next, after you file the application, nowadays it's all done online. So once you file the application and all the formalities have been done, so the registrar, the officer there in the trademark registry, he will be examining your application and he will see that the application is in order. So if there is any problem, he will give you an opportunity to make some corrections. It should not be a substantial amendment, which is changing the nature of the applicant. Like if you move for, say, a mark A, you cannot say I want to, change the mark itself and make it mark B, totally different. So that kind of amendments are not possible. But there are small mistakes or any other thing in the application if it's there. So those things can be corrected, and he will issue an examination report to the applicant, and he will ask the applicant to file a reply if there is any if he feels that the mark is not distinctive, or there's any the goods are not properly mentioned, or a wrong class of goods were mentioned, like say for instance there's metals and all, they fall in class 6 of the Trademarks Act, but you filed it in, say, some other class, say 8 or 9, then he would say give an objection saying that this application will not be filed in class 8, it will be in 6, something like that. So these things can come as objections, and if required, he will give us an opportunity of hearing also, where you can try to justify your application and that the mark should be registered. So if the registrar is convinced, then he will accept the application, will be advertised. There's a trademark journal in which all the marks, the accepted marks, are advertised, so that any member of the public, it is open for the public view, and if anybody has an objection, they can file an opposition. There's a 4-month window where anybody who, if somebody files that this mark is going to conflict with the same mark which I am using, or it is very similar to, it is going to affect my business in some way, whatever reason, if he has a valid reason, he can oppose the application within a period of 4 months from when it is advertised in the trademark journal. Next. Yeah, so within 4 months from the date of advertisement, anybody may oppose the application. So, and if there is no opposition filed by anybody within a period of 4 months, the final step is the registration certificate will be granted under the seal of the trademark registry. So, and the time period for getting this registration would be, if there is no opposition, of course, it would be some say 6 months to a year. Generally, these days, the registration certificate is issued. Yeah. Next. So next, we can see what is trademark infringement. So the definition of infringement is that if another person is using uh, a trademark or a business name which is substantially identical or deceptively similar, he just writes, he just messes up the spelling a little bit, and uses it in a way like but when you see it, it resembles or it brings to your mind the other trademark. So this is called a deceptively similar, little bit changing the spellings, and all that. So substantially identical or the same trademark, same color combination. The moment you look at that product, it reminds you of the other product. So people will be like, I've seen Fair and Lovely, it's like packaging and all that, but it's not actually Fair and Lovely. It's something little bit different, so substantially identical and deceptively similar to the registered trademarks on goods or services covered by the trademark registration. So if it's a registered trademark and somebody is using a substantially identical trademark, so it will amount to an infringement. So and what is the main reason? So it's likely to cause confusion in the minds of the purchasing public. So whoever looks at this trademark, he gets a doubt whether this pertains to this person. Like I have been doing certain cases of Harvard, and there was many schools or institutions who also started under the name of Harvard. So people got confused whether it's actually affiliated to Harvard University, and they used to write to Harvard also. And there was a doctor who was just saying that he is affiliated to Harvard. So people wrote back to Harvard University asking them that this doctor, actually associated to Harvard. So this kind of things do happen when similar trademarks are used. So that amounts to infringement. Next. So when this kind of any questions till now? Sorry, I forgot to ask. Is there anything till now anybody wants to ask?
I think Nilay has some. Your hand is raised, Nilay.
Yeah, please.
You're on mute. No, maybe he accidentally raised his hand. So, anyway.
Okay. Should I continue?
Yeah, I think so. Yeah, there is some question from Aparna. Can an objection be raised after 4 months? That is what she is asking. Aparna has.
Now you can hear me?
Yes, yes.
Yeah. See, this is actually objection can't be raised after 4 months, then the only 4 months is for filing opposition proceeding. So the registry has a time, it can't be indefinite. If they're advertising it, if you have any objection, you have to file the opposition within 4 months. If you're not doing so, by chance it happens that you never came to know of the mark was advertised.
Oh boy,
Yeah.
There's some disturbance.
Yeah. So like I was telling you, sometimes you never come to know that the mark was advertised and you missed
Right.
the deadline, right? That case you want to know, right?
Yes, correct, right.
In that case, the registration will be issued. Okay. Later on, you can file a rectification. After then you have to wait till the mark gets registered, And after the registration, you can file a cancellation or rectification to the registry. You know
You
that
mean to say
this,
the cancellation of the person, I mean, the person who has done it, cancel his whole entire registration later on.
yeah, because see, it's an automatic process. The registry will wait for 4 months. Okay, so
Right.
automatically, if you don't file an opposition within the period of 4 months, it will automatically get registered, right?
Right, right.
So after registration, you have to then attack not the application but the registration. If
Okay.
you want to, right?
All
You
right.
have to file. That's called a rectification proceeding, and that's
Okay.
almost like a lawsuit. You know, you have to.
Yeah.
It takes place. Hearings will take place, and you have to challenge the registration, and you have to tell why it should be cancelled. You know, like you have a better right, or you were the owner. All these things you have to allege, and
Okay.
you have to get it cancelled. Right.
All right. Thank you so much. Thank you.
Yeah. Sure. Can we go to the slide, please? Next. Yeah. So this is a like infringement action. So infringement is always related to the registration. So the moment you say infringement, it always pertains to the registered trademark. For an unregistered trademark, there can't be any infringement proceedings, right? So because it's a statutory right, it stems from the registration only, the infringement. So an action for infringement, which is a statutory right, is dependent. So in the main thing, in the infringement proceedings, you are going to attack the validity of registration of the trademark. So so we presume in law, it is presumed that once a trademark is registered, it is you are the owner, right? It is a prima facie proof of the ownership of the trademark. So and there is a limitation for filing the suit for infringement. That is when you came to know that somebody else is using my registered trademark. So the moment you have to allege the knowledge of infringement when it came to your notice, and within 3 years you have to take action against the infringers. Like if you are just allowing, you see somebody using a trademark which is similar to your registered trademarks, it's in your knowledge, but say for 5 years you don't take any action, you are saying, yeah, let him use, I don't care, now it's not pinching me, and tomorrow his business grows to a large extent and now it starts pinching you. It was in your knowledge but you let him use. So after 5 years you just can't go and say, no, you just stop it, you know, because if that person is able to prove, like you gave him a notice and then you didn't take any action for say for a long time, say 5 years, and suddenly after 5 years when you see he has grown, you go and you can't stop. So there's a limitation, 3 years, when you came to know. So and what are the remedies that you can get? So one is the injunction, that you restrain the use of the mark, and then unjustly what he has gained due to this use, you can claim for damages, or you can, and also you can ask him to surrender all the labels and marks and all that and get it destroyed. And also you can take criminal actions also, and you can search and seizure and all the infringing goods, you know, a local commissioner can be appointed and the infringing goods can be seized also. So these are the remedies available if your trademark is registered. Next slide, please. Yeah. So this infringement proceedings were in relation to the registered trademark. So as far as the unregistered trademark is concerned, because as I told you earlier, trademark law is more related to use. So use is a very, very important. Take a case where a person is not registered as trademark. He's bona fide being having used it for he's being been used it for several years, but still somehow he didn't get registration. He didn't know about it, or he couldn't get it due to some reason, or there was some problem in getting it registered. It could be any of these cases. So in that case, how does he get protection? Because in trademark, as far as trademark law is concerned, use is always, even if you vis-a-vis the registration, use is always accorded more importance, like bona fide use and adoption. That stands a better, ground than, just getting a registration. So that, in that case where the person doesn't have a registration, he will resort to passing off. So it's actually, passing off is a tort basically, and it is a common law remedy. It's not under the statutory. It's a common law remedy, and the main purpose is to, over a period of time, when a person is using the trademark, he has built a goodwill for himself. So, and the law does not want that just because he didn't get a registration, somebody else, uses his hard work and his goodwill. So the law wants to protect that goodwill. So that another person should not take the labor of somebody. So even if it's not very well known, the owner of a trademark, he can initiate a passing of action in a court of law. Because otherwise it needs to also be protected, because if the products are original and somebody else is going to put false products on the market, and customers may be deceived. So it is very essential to safeguard. So in a passing of action, since you don't have a registration and you don't have anything to just show that I am a piece of paper to show that I am the registered proprietor, or I've been using since such and such date. So that thing is not there here. So then what do you have to prove? You have to prove that that you have a goodwill, and so many customers know you, and maybe you have to file affidavits for that, and bills and invoices, and you have been supplying goods, you have been selling goods, and on the goods these trademarks were mentioned, and all these things have to be proved. And so first thing is you have to show that you have a goodwill, and secondly you must show that the other person's product is so confusingly similar to mine, and it is bound to cause confusion. And the third thing that you have to prove is that I'm going to face damages, I'm going to face a lot of hardship and in my business if this is going to be allowed. So these are the elements that you have to prove in an action for passing off. Next. That's it, I think.
I just want to add
So
one
this is the,
thing in the trademark section. Sujata is telling about the classes. So we have all services in trademarks as per trademark rules divided into 48, right? 48.
45 classes. 48.
45. Yeah, you're right. So total goods and services that you can think of, and it's a global classification that's there.
Yeah, so nice classification.
Yeah, these are as international classification. So anything you can think of, say for example, there is a Maruti car also, and there is a Maruti oil also, cooking oil. These are two different classes. So, and these are two different companies. What the courts have said, if they are in a different classes, perhaps you can, because the goods are different, people are not going to get confused. Nobody is going to get confused from Maruti car and Maruti cooking oil. So there are several of these kind of marks which are in a different class. And so the courts say, okay, you can have these marks in different classes itself. But the Trademark Act also talks about well-known marks, which is they will spread across their reputation, spread across all the classes. For example, Tata or Reliance. They make products in all the classes that you can think of. So
most of the classes.
Yeah, their reputation spreads across all the classes and all the jurisdiction, all the countries also. Example is Microsoft. It's a well-known mark. It is whether you are in any country of the world, there is good that you are using the Microsoft operating system. and likelihood that you are going to you are going to uh, infringe upon their mark if you use Microsoft as a word. So that has been the position of the court, that if it is a different class, it is going to be different rights that will accrue. The second thing which recently I was talking about, this case of Coronil, is it happened in COVID-19 period also, where Patanjali, Baba Ramdev's Patanjali has come out with Coronil. I think it's a medical herbal kind of medicine.
Yeah, syrup person.
So they went and started marketing it. There is also Coronil pesticide, which is in a company registered in Chennai. They filed a case saying that Coronil word cannot be used, and it is the same class also. It belongs to the same pharmaceutical and drugs kind of class. So matter went to Chennai court, and it's a registered mark. The Chennai one was registered mark, the company. They went to Chennai High Court, and they got not only a stay, but they got 10 lakh rupees as damages from Patanjali. Anyway, so that now that I'm surprised, and I'm also, it's very interesting. Supreme Court has said though the class is same, but the goods are within the class also, the goods are very different. One is pesticide and the other is a treatment. So it has vacated the stay that was given by Chennai High Court. So this is pretty strange, but yeah, this is also the law of the land, that if the goods are very different, then you could perhaps have the same mark, provided they are not well-known marks.
Dinesh, there was this China case also, if you remember, where the BD, there's a BD and smoking tobacco. And the Supreme Court said that those are different, both were tobacco products.
Yes. BD and tobacco are separate. So maybe they gave the same trademark to both of them. So
yeah, I think chewing tobacco and BD or something like that.
Yeah, I remember there was this case, very famous case, where even when within one class, if goods are different, the courts have to.
Yeah, because I think even within a class, there are hundreds of goods.
Yeah.
So by trademarking, that's why I think many of the examiners ask us to be very specific about the goods. Because for trademarking for one goods, you're just using in one goods. You can't say that entire class I have the monopoly for everything, for hundreds of goods. So in what particular goods you are using, again it comes to the same thing, the use of the trademark. That's also very important.
Right. All right. Is there a question? I can see Lakshmi's hand raised. Anyone raising hand has a question right now on trademarks? Yeah, Lakshmi.
Sorry, sir, that was my mistake.
All right. Okay. No worries. Who else? Any questions on trademarks? Let's see the chat, if there's any question in the chat. All right, no questions. All the questions are answered. Okay. We'll move on to the next section, which is, let me share the screen. Thank you so much, Sujata. That was very, very informative. And now we'll move on to the copyrights. I can see two participants' hands are raised. One is Sanket. Is it by accident?
Somebody has a query here. Is YouTube channel to be registered as a trademark?
Is the question in the chat?
Yeah.
His YouTube channel is to be registered as a TM. So of course you can register your trademark as a channel, but there is no, I mean, why to restrict it to YouTube channel? Okay. So for example, domain name you can trademark. So you can also trademark if there is a unique name, which is not for any other television or for any other channel, you can trademark it. Does that answer your question? Okay. Ajit Singh, if we copied a logo from Google Images and changed it a little bit, can we use that? Of course not. So as Sujata had mentioned, that if it is deceptively similar, the definition of a trademark infringement is if the logo looks
Similar, yeah.
almost similar, then you cannot use it. So the person can get confused on that. Okay. But if you do substantially create your own logo,
Yeah.
an idea from some Google Images, create your own logo, then of course you can go ahead and register that.
But main thing is if you cannot trace it to the original image, then okay. But if it has resemblance to the original, then obviously it will be an infringement.
All right. All right, so we'll get back to our slides. Let's see. So we were on copyrights, right? Oh. Okay. Copyrights, as was mentioned by me earlier also, they are work of authorship, original work of authorship. They are fixed in a tangible medium of expression. Tangible medium of expression could mean a book, a CD, a pen drive, a hard disk. So that's a medium of expression. Okay. And original work of authorship means it should be something like this. PowerPoint presentation is original. If I write an essay, it's my work. If I write the lyrics of the song, that's also my original work. If I give music to it, that's also my original work, right? So anything that you do originally will be a work of authorship and nobody could copy that. For example, this particular presentation, the Zoom classes are being recorded and I upload on the YouTube. And if somebody takes a part of it and put it as, or even refers to it, he's not able to do it because I have the copyrights into it. Just because I have put a piece of work in a public domain does not mean that I have given away my copyrights. Okay. It would still mean that I contact the public, the author of the presentation and seek permission that, look, I want to reproduce a part of this presentation because it's very important. Same goes with movies, same goes with songs. So it is, it's, so many songs are available on YouTube. Okay, you can go and watch free of cost. But the moment you play it commercially or the moment you use it for some commercial, the moment you put that on your website as your own, that calls for an infringement of copyright. Okay, it's a very tricky law. Copyright is a very tricky law. People are putting books and magazines on the internet. For example, there was a big controversy recently when the COVID started, people started distributing newspapers, right, on WhatsApp, because the physical newspaper stopped coming to the homes of the people, and people started forwarding the newspapers, right? So how is that? How will that impact uh, the publisher, the newspaper publisher? How is that going to be impacted? Can anyone answer? Is that legal to do it, or it's illegal to do it? Let me try to ask that question from you. People forwarding newspapers on WhatsApp group, which was very much prevalent like a month back. Any answers? You can raise your hands, and then any answers from that perspective? Okay. To be honest, this was not. It's illegal to distribute the newspapers in WhatsApp. I don't know how many of you got them, but it's a very clear law. Even if they are publicly available, even if the Times of India website publicly gives them, but at the same time we cannot distribute it further. Okay, so it is not a legal practice to give newspapers. It's a copyright violation, because Times of India did not authorize you to give their newspaper as a forwarder to the WhatsApp. They may do it. They may give it publicly. They may give it if you are subscribed to their WhatsApp group. They may give it if you are subscribed to their website. You may download it from their website. But you cannot further they have not given you license to further distribute it. So it's a bit of tricky law, copyright. And one more example that comes to our mind is remixes that come. Nowadays, there are a lot of remixes that come for the songs. Now they take a bit of snippets from previous old songs and combine it and give one song to that. Is that a copyright violation? So there is that an intellectual property? They have not taken permission from the original singer or the original lyric writer. But they're using those lyrics, but they're using it for very short time, like 10 seconds, 15 seconds. So is copyright being violated? There are these interesting questions that come. Caller tune, caller tune is another example. Is the copyright violated when Airtel or you put a song in the background and somebody calls, there is a song going on? Is that a copyright violation? So these are some of the big issues that keep on coming to the court from intellectual property rights perspective, right? This song came, Salman Khan, Jhandu Bam. Now he's using a trademark of Jhandu Bam actually. So Jhandu Bam se main to munni badnaam hui Jhandu Bam wala, that song. So can they use that particular trademark into their songs? Will that be a copyright violation, or will that not be a copyright violation? Right? So again, these are some of the. Okay. Sanket is asking me a question. He's asking, putting old songs in remixes is not a copyright violation, as the remix itself creates a newer beats for the particular new song. Is this correct? Well, in my view, it is still a copyright violation. If you are using the same lyrics, at least the lyrics are being violated, right? So a song has three kind of copyrights. One is the lyrics itself, the other is a tune, and the third is also the broadcast right. The complete motion and the complete lyrics of that. So maybe two of the copyrights are not violated, but lyrics is, he's using the same words, right? And he's commercially exploiting it. So that is a copyright violation. Whether they have taken the license or not taken the license, we don't know. Whether they have, the original author is not able to prove its ownership many times. They're not, I know many of these songs by Saregama, they are even unable to prove their ownership, that this song belongs to them or this lyrics belongs to them. Where is the copyright certificate for them? That's a separate game of evidence. But as far as the law is concerned, having a remix song, they are in violation of copyrights because they have taken a bit of lyrics from the previous song and then also exploited that commercially. Okay, so we'll not go into these debates. These are some of the advanced kind of cases that are going on. I thought perhaps it might be interesting for you to know these kind of issues because these are like modern days issues, like I was telling you about the ringtone being there. So that is another kind of challenges that are being thrown to the courts these days. Okay, again, I'll share my presentation. All right. And as I said earlier, the copyright lasts for lifetime of the author plus 70 years thereafter, so that their children and grandchildren also enjoy some kind of a royalty, right? So, for example, my father had written 60 books. Now he's no more, but I get the royalty today also of the work that he had done. So this is what the power of a copyright is, or the royalty from the copyright is, that not only you enjoy it, but your children also enjoy it. Is there something else also in the chat? Using the same lyrics and alternating the related right around the song, is this violation? Okay. I didn't get that part, but we'll take it. We'll take it later, Sanket. I didn't understand the same lyrics. Means the same lyrics were they like a copyright earlier, or they were not a part of the copyright? Okay, if they were the same lyrics were part of the copyright, and you are altering the related right around the song. Now, how you have done? Can you trace it back? As Sujata mentioned, the test is: can you relate these lyrics to an earlier song somehow? Then it is a violation. At the end of the day, that is a violation. So anyway, some of the cases can be borderline. I'll be very honest. Copyrights and intellectual property rights is, at the end of the day, it originates from science, but it is not a science. At the end of the day, it is arts. It is very, very subjective, depend from person to person. Okay, copyright registration is not necessary, but it's necessary only for enforcement, not for ownership. So, for example, this presentation that I have made, I will not go ahead and get it registered at Copyright Office, because that will be so much tons of work that will go to them, and it's not so important also. But if it is an important work which is bringing me lakhs and lakhs of revenue in terms of books or in terms of a movie or a song, then I will get that registered at the Copyright Office. Though I can file a case that somebody on this presentation also, that I owned it on such and such date, I presented it to the group of people and I had uploaded it on a YouTube, and I haven't got a copyright registration. But I have the ownership of this and I can prove it. But when I need to go to court, I need to have a copyright registration for that. Because the first thing the court and the police will ask you is, aapki hai kaise register kiya hai ki nahi kiya hai? You know, that's how they ask you. A company is the owner of work. If you are an employee of a company and you create a presentation, or you create a software, or you create anything, or you create a website, it does not belong to you. It belongs to the company. Okay. So there is one work of hire and work for hire. Okay. Where there is a contract, then it is a work for hire. So this is a contract, and you still need to own a copyright by virtue of that particular contract. But if you are an employee, automatically it vests into the company. Though many of the offer letters, when you go into the company, they give you an offer letter. They, by virtue of that also, the copyright vests with an employer. It does not vest with an employee, right? So if you are in a software company, any code that you make for that software, it belongs to the company. It does not belong to an employee. Okay. But if employee in his free time writes a book on cooking, that belongs to employee himself. That is his, that's not covered by his company's objectives. Okay. So again, copyright, though belonging to an employer, but we also have to relate it to the field that the work that he was given to do. Again, use of proper legal notices. Use proper notices. I don't know if you know what there is a way that you write a legal notice, a copyright notice on all the material. I can quickly show you. Let me see if I can. I'd like to show you quickly on how we do that. This is our IALM website, if you haven't visited it already. Yes, you see this at the end. This is a copyright legal notice. These products on this website were created from 2013 to 2020 and belongs to IALM. Okay. So this is a copyright notice. Okay, even if you do not see a copyright notice, don't presume on ownership. Do not make copies of an article, paper, or any third-party copyrighted work and distribute copies around the college. Do not download any illegal MP3 files or similar technology to your computer. So you do not download the songs, do not download the movies, because all that you may think is freely available and downloadable, but again, it is illegal. Be very careful on that. Okay, because all that is illegal. There are technologies which you can trace the IP address and actually know which machine or which MAC ID downloaded that particular song or that particular movie, and they can trace to your computer and can give you a notice on that. So one of the there are tools available that help companies in actually locating where the piracy is taking place. Okay. Okay, any questions on copyright? Otherwise, we'll move to the next, which is again a very interesting part, trade secrets. If there are any questions, you may raise hand or write it in the chat box for the copyrights. Okay, there's none. So we'll move forward. Trade secret, again, very important and very powerful form of intellectual property rights is trade secrets. And many companies use this as one of the very important tool in gaining competitive advantage in the market. Earlier we shared the example of Coke. Okay, so Coke is a perfect example where the secret is kept in a big locker in Atlanta, and there are only two keys which both the CEOs keep with themselves, and they don't fly together, and they are not supposed to be in a single city at the same time. So there are rules governing that, and so that's how the accessibility to this big secret, which has been kept for more than 200 years, for the Coke. So nobody can make Coke easily. And mind you, had they patented this 200 years back, what would have happened? You know, the founders at that time thought of this intellectual property to be kept as a trade secret, not to patent it. Had they patented it, patent is only valid for 20 years. Okay, and for each patent application, you have to it gets published also. So had they patented it, this would not have this would have come in a public domain, and everybody would have been making Coke today. So again, that's why I always emphasize that trade secret is many times much more powerful even than the patents. But unfortunately, India does not have the trade secrets law, so we have to rely on trade secret by way of contracts. But anyway, so trade secret is equivalent to confidential information. This information must be secret, not accessible. It must have commercial value, and the owner should have taken reasonable step to keep it secret. I mean, I cannot say it is my trade secret and then publish it on my website. It is no longer a trade secret if you publish it on a website. So you should take steps. The owner should have taken steps to keep it secret. Okay. This information can be written or simply in someone's head. Normally what the corporations do is they have kind of trade secret form or a disclosure form where employees can, if that idea, invention disclosure form, that idea is not patentable, they will keep it as a trade secret so that the other employees can refer to it also. So it can be, I can remember it, or I can put it in writing as the Coke has done. Examples of the trade secret are technical and legal information, such as how something works, what doesn't work, method and technique, R&D, unannounced product specification and prototypes are all example of trade secret. Business information, pricing, future product roadmaps, release of your products, customer list, employee list, sales goal, performance goals, target features, M&A plans, all these are part of their trade secret. Okay, they cannot be shared outside a corporation, because if you share it outside the corporation, it amounts to infringement of copyrights. Many employees are sued on the basis of this trade secret. Even in pandemic, I got 2 cases myself where, because the employees were given laptop at home to work, they somehow accessed the network and either downloaded the source code or downloaded the customer list. And the employer now wants me to take action. We have taken action in both of these cases, and these are also sort of cyber security breaches. And because of that, the complaint has gone to the cyber cell and breach of IPRs, of course. And so some of these things are to be taken very, very seriously, whereas patent is published, so it cannot be stolen. But trade secret is a secret which an employer tells you, and as an employee, there is an obligation to keep it secret. Okay, this is something about trade secrets. What we can do is, if everyone is okay, should we take a 10-minute break right now? If we can take a 10-minute break and reassemble at, what's the time now? It's 5. If we can reassemble at 5:20, okay? And then we have, I think, designs left. And what else? Let me share the screen. Yeah, we have enforcement of IPRs. We have only 2 small topics left after that. I suggest what we do is just take a 10-minute break right and come back after at 5:20, everyone. All right. Okay. All right. Bye bye. Okay, the question from Sanket is post-grant opposition similar to infringement filed in the court to stop the use of some trademark? Or is there any difference? How designs can be patented? The first part answer is no. The post-grant opposition that happens in a trademark case will result into either you win either the trademark get registered or it does not get registered. So there is a difference between both of them. It does not have any impact on your business, right? If in a post grant, suppose I am the owner of the mark IALM. Okay, I am the owner of the mark. I have filed for registration and it has got opposed and I lose the case. Okay, I lose the case. But that doesn't mean I cannot use ILM. I have just lost the rights to register an ILM. Maybe because there is a word Indian in it. You know, their trademark office is very reluctant to grant registration where the word Indian is written. They say, why, how can I trademark a word where Indian is written? But that doesn't mean I cannot use it. I can go ahead and use it. Okay, I have my rights, as Sujata was mentioning, even without registration, just because I am using it from long time. It's called passing off. I can still stop others. But if the matter goes to court, the court grants an injunction against ILM, then I cannot even use the word ILM. The court has much broader power, I will say. Okay, you got the difference between the result of opposing a trademark at the trademark office in a post-grant situation and the difference going to the court. In the court, there's an injunction. It just stops my business then and there if the court grants an injunction against me. So that's the first part. I hope you got the difference between proceedings in the court for a trademark and proceedings for the post-grant opposition. How designs can be patented? Designs are registered under the Designs Act in India. We don't use the word patent for design, but many countries do. You know, they call it a design patent. So design in a design application, and we'll be doing design just now. I think the next section is for the designs itself. We need to give to the design office the pictures or the photographs or the three-dimensional figures which describes my design. For example, in an automobile, I want to protect the side view mirror, okay, the way the side view mirror looks. So I have to give the side view mirror from 10 different angles, that this is what my side view mirror is, and the design office or the patent office will check it and grant you a design registration. It is a much easier process. It takes around 6 months, whereas a patent can take even 3 years to get it registered. Design is much easier from that perspective. Okay, so that's your second question from design perspective. All right, so let's go to our slides now. Okay, this we did, we've done that. Yeah, these are the designs. Okay, you must have seen the earlier Tata Sky channel kind of design that used to come. So this is a pattern for graphical interface, the way Windows look, the way iPhone looks today. It's called UI, user interface. So any user interface can be design patented or design registered. In India, I will call it design registered. Okay, so that no one is able to make the kind of icons that are there in an Apple phone. The icons that are there in the Apple phone are different from the icons that are there in the Samsung phone. Okay, so because everyone has a different design there, so it's called a user interface. The layout, you can say, you can protect it. I gave you an example of an automobile also, right? So that's another kind of, for iPods, you have different. This iPod is nothing but, if you see, it's kind of a storage, right? But what it has is it's a very good kind of a user interface. You can play songs, and you can you can create albums. So again, that's kind of a design that has been protected by Apple. So here we are. Okay, so again, design is very, very important from manufacturing perspective. How your product finally looks, how the Apple phone looks will be different from the corners that are there for the Samsung phone, or how a television look will be. Even the bottles, if you see the perfume bottles which are there, they're all design patented, design registered in India, so that no one is able to make the same design again. And there are thousands and thousands of new products that are coming in that require design registration. Okay, so that's pretty straightforward. If there's anything, please you can put it in the chat. I think there's something that has come. All right. Now I will come to which is very important part, is the enforcement part. So in enforcement, let me just. Yeah, enforcement of IPR. This is again a very, very important field, and every IPR professional should know. What if once we get a patent, or we get a copyright, or we get a trademark, how do we enforce it? I can quickly tell you, for the patent and trademark and design, and that will be followed in a similar manner, and same kind of remedies are available in other kind of enforcement of IPRs. But from patent perspective, it's a little different, because in a patent, I don't know how many of you have seen a patent. In patent application, you actually claim your invention, and when you claim your invention, you actually write, I can do these things, 1, 2, right? So I can do these 3 or 4 things. This will, and if I find a kind of infringing product which says I can do 1, 2, 3, and 5, there is no infringement, because my claim, my patent claim was 1, I can do 1, my product can do 1, 2, 3, and 4 things at a time. Whereas product that is alleged to be infringing can do 1, 2, 3, and 5. Now, if he says my product can do 1, 2, 3, 4, and 5, it's still infringement, because my claim was 1, 2, and 3, 4 elements. I hope you are getting it. I mean, if you're not, you can just send me you can send a chat message and we'll discuss it. But it's pretty straightforward. In a patent, you have to claim certain features. new features, and if you were claiming 1, 2, and 3, 4 features, whereas the infringing products seem to have 1, 2, 3, 4, and 5, it is still an infringement because it is covering my 1, 2, 3, and 4. Okay. Now I go to, there is a product which is 1, 2, 3, and 4 prime. 4 is just a very small change, obvious change that he did from my total claim. So this is still, there is infringement, I will say, if it is a small change that he has done in any of my elements that I have claimed. Okay. And again, if it is only 1, 2, and 3, 4 is missing, there is no infringement in this case. Okay. So this is as far as the patent is concerned. Patent, in a patent infringement case, you actually have to look at what you are claiming as an invention. You know, if I am claiming, say, a tire that has certain features, that has certain composition, which consists of 1, 2, and 3, 4 element, then I have to look if there's a tire with these kind of compositions, okay, or there's a molecule in a pharmaceutical invention, there's a molecule that has these invention, then only it will be considered to have been infringed. Okay. Again, this is again a scenario of a patent claims being. Now, if I am claiming something again with an element 1, 2, and 3, and 4, this is with respect to prior art. You know, patent, as I said, is something that has to be new. Okay. Now, if I show to the court, no, this is nothing new. Okay. There is a prior art that existed, or there is something that existed, and this patent should not have been granted in first instance to the court, then what is my defense? Okay, I can get the patent invalidated if I can show there is a prior art that has 1, 2, 3, and 5. This prior art is invalid. Okay, because this prior art is not exactly the same. So my defense will fail. Now my defense will be valid if I can show there is a prior art with 1, 2, 3, 4, and 5, because 1, 2, 3, 4 already existed. Okay. Now I show 1, 2, 3, 4, and 3 and 4 prime. So in this case, we have to show that whether 4 is same or it is not the same, right? This is a case, the last scenario is when the elements 1, 2, 3 are present, then whether it is prior art or not will depend on the you know, if 1, 2, and 3 are already present, in the prior art and it's performing the same thing, then this element is not required. So it's a valid prior art. You could do the same thing with element 1, 2, and 3, whereas I am claiming 1, 2, and 3, and 4. Again, this will hit as a prior art and will be a valid part of it. Okay, I hope you understand. A very specific scenario from patent perspective. Am I audible now? I don't know. There's a comment that am I audible? All right. Okay. All right. So this is.
Yes, Dinesh. Now it's okay.
Okay. All right. All right. Okay. Well, so this is very specific to the enforcement in patent claims. Okay, and the whole litigation. I don't know how many of you have seen a patent litigation where you enforce a patent. The whole litigation moves around whether the infringing products has the same element or the prior art has the same element or not. Okay, and then the judge actually decides based on these parameters whether your claims are valid or not against the infringing products. There's a huge litigation, especially in the pharmaceutical, biochemistry, molecular biology. I know these words are at the end of the day, this is related to science, but at the same time, the counsels, the arguing counsels in the court need to know all these terms and all these terms of the claims, so that they can argue well in the court and inform the judge, because judges may or may not have the scientific background, or the lawyers may or may not have it, but it's very good to explain it probably through these diagrams that how this is infringing. Okay, all right. So this is a typical patent litigation. My last slide on legal programs for IPR enforcement. And to be honest, I have done all of them in one or the other stages. My firm does it. When there are IPR infringement, many of these remedies are available, which you. One is, of course, if you feel that your client's products are being infringed. Suppose I am representing the company Colgate or Hindustan Unilevers, and we find that there is counterfeiting and there's huge amount of, somebody is misspelling and selling it in the market. We may have an option of educational letter. This may not be successful in educational letter, because people are deliberately counterfeiting it. Counterfeiting is something very, very deliberate. But if they are doing it accidentally, many times my educational letter helps them, especially in terms of software or movies download, they may not be even aware that they are doing a piracy. So this is where educational letter helps me. Second is an audit letter, as somebody might be pirating my software. The moment you do a download of a software, you would have to still go and agree to the terms and conditions of running the software when it gets downloaded. And one of the terms and conditions is, even if it is pirated, I have a right to audit your computer. So I can send, and it actually means an IT audit of your computer. And if pirated software is running in any of the networks, I automatically get a right to audit, do an audit, and I can give an audit letter and say, look, I want to check your computers. I want to check your premises, come on such and such date with an expert, and I will do an audit of your premises. So these kind of audit letters are also effective and scary. People who are doing piracy unknowingly or even knowingly, they will get impacted by these audit letters. Third is a license letter. Most probably it is used in in software cases, these license letters, and you can actually say that, okay, you are doing you're copying my technology, and these are my technology transfer agreement or my license letter. If you want to continue to do this manufacturing, you will have to take a license from me at such and such rate. So these license letters are being used by lawyers to initially start a conversation of companies giving IPR royalty to them. Okay, so you can send these license letters. Again, every of these format is different, and every of these remedy is different. But at the same time, they can be pretty impactful um, in getting your copyright or your IPR being licensed. The fourth is cease and desist. Again, a very important form of remedy, a legal program, I can say. You can ask the infringing party to cease and desist. Cease and desist is nothing but a legal notice. At the end of the day, it is like a legal notice, but more of this word is used in IPR enforcement. So if somebody comes and tell you C&D, I have to issue a C&D. So you should understand what actually it means. He wants to give a legal notice. Of course, it has certain clauses which are very, very different from a normal legal notice. It has those IPR related clauses. And I can see a question from Sanket on, is license letter is similar to franchisee? See, franchisee and license is little different. Both have the same meaning. Franchisee is mainly given for, I know it's an IPR only, but at the end of the day, it is given for, say, restaurant, where there is goods and services being given, or for, say, a franchisee for a showroom, franchisee for shirts, franchisee for Nike, Adidas. So mostly there is an element of, uh, royalty there in terms of using your logo, but franchisee deals are different from licensing deal. Licensing deals are purely uh, uh, are purely the license will be purely based on your IPR transfer. Okay, there may not necessarily be any goods or services being given. For example, if I have a KFC franchisee, it will make sure the design is also mine. It will make sure that the chicken comes from my farms, and so, and if it is a Nike or Adidas franchisee, it is the goods that come from my manufacturing place. But from licensing perspective, it is only the IPR, the patent is being licensed, or the copyright is being licensed. Its license is more of an IPR based, whereas franchisee and goods is more of franchisee is more of goods and services based that gets transferred. There's a thin line, I understand, but there's the way the business runs is different in technology transfer agreement, licensing, and franchising. So these licensing letters are only purely for enforcement of IPRs that we have to issue. Then finally, if all the above four efforts fail, educational letter fails, audit letter fails, license letter fails, cease and desist fails, there is always a suit for injunction and damages that you can file in a civil court. And this cease and desist will be, I mean, if the cease and desist failed, then the suit can be filed in a civil court, it can be filed in a district court, it can be filed in a high court, depending on the damages being sought and depending on the pecuniary jurisdiction of the court. You can file an injunction and damages suit. You also have an option of raiding the defendant by appointing an ex parte local commissioner. Most of these cases that take place, an ex parte local commissioner is appointed to seize the infringing goods or seize the infringing material. So there is suit for injunction and damages that you can go ahead and file it in the court. The other legal option is to file a criminal complaint, and criminal complaint is also of two types. One is under section 202 CRPC, where you approach a magistrate, local magistrate with the complaint, and local magistrate will take your evidence. It's called a pre-summoning evidence. He will take your evidence and then issue a notice to the opposite party. Mostly this is done when you do a test purchase. Okay, suppose somebody is selling some shoes, Adidas shoes, which are fake. And what I do is I go to his jurisdiction, collect all the evidence. I do a test purchase, take a, preferably a bill also from him. And then I submit that in the magistrate court and say, look, he's doing this complaint and this is my, notice. He should be tried under the offenses under Copyright Act and under the Trademark Act. And also counterfeiting under Indian Penal Code, cheating under Indian Penal Code, and I submit the proof, and the court take cognizance and sends him a notice, and at that time he has to come and get the bail done. The last remedy, I mean, these are not exhaustive lists. You can think of, be more creative and think of more ways to enforce your intellectual property rights. The last is a police complaint. You directly go to the police commissioner's office and you say, go and seize the good. You give a complaint in writing, and the police registers an FIR under 156 CRPC. It registers a first information report, and then it goes. But police is, for them, the counterfeiting, to be honest, in India, IPR offense, they think it's like only like a traffic light violation, and they don't take it too much seriously. So police, if you go to a police station, they will say, go to court. We are not doing anything. Until and unless there is a big pharmaceutical kind of a product or a food product where the public health is involved, police will come and take action. Otherwise, for police, somehow I have noticed it's a low priority for them, and they don't directly lodge an FIR. So you have to go with option of criminal complaints if you want to file against the infringing party who are infringing on your IPRs. And especially for patents, is sued for injunction and damages, along with an expert evidence that we do. So these are some of the legal programs. Of course, there's much more deeper connection and deeper details that we need to go before deciding. Many times it's difficult to decide which kind of IPR enforcement strategy that you would need to implement in a particular case. So these are some of my thoughts. I will stop here and first ask if there are any questions from anywhere in the presentation, any section. Me and Sujata will be happy to answer that. And Shreya is also there to help us. So anything you feel. I know this was an introduction. You need to go into much more details, but just gives you an overview of the environment that we have from intellectual property rights perspective in terms of what the business strategy is, how do you protect it, and thirdly, how do you enforce it, which is much more important these days. As the counterfeiting increases in Indian market. So this was an overview. Again, I thank everyone for attending this and being patient and hearing this. But let me see if there are any questions. I'll just stop here and ask if there are any one of you have any questions. And you can switch off your video and unmute yourself also. All right. So if there are no questions, I'll be available offline. You can always write to Shreya or write to me directly. I am very active on LinkedIn. You can get in touch with me if you have any further questions. I'll be happy to answer. I can answer now also, but since we have some time. But if something comes to your mind later on, we can take it. I can answer that later on. And Sujata is also available as an integral part of IALM. Thank you so much for attending this. So Shreya, you want to end this session? Oh, Shreya is not there. Yeah, Shreya, you're there. All right. I think Shreya is also. Yeah, you are on mute. Okay, I think probably I'll end this session then. I think Shreya is on mute right now. And as I mentioned, thank you everyone for joining this session. I hope this will just give you an overview of intellectual property rights and whatever you are doing in whatever jobs, vocation, profession you are. I'm sure IPRs is going to touch your life, and it will touch your profession, activities that you're doing, and it's a never. Even I am learning after 25 years. Also, I'm still learning new things in IPRs, new invention. It's a very interesting field, and I encourage everyone. If you can't make it as a full-time profession like me, but at least have interest in it, in terms of how do you monetize your IPR, how do you monetize your assets, intangible assets. So with these words, I will call off this session, and thank you everyone for joining. I hope that we'll be able to interact more in future also. Thank you so much. Bye.
Thank you, Dinesh. I would like to say thank you so much for this great learning, and thanks for the opportunity to provide your, time and to contact you further in case if we seek some kind of support. Thank you, Sujata.
Thank you, Naresh ji. Thank you. Hope we'll all be in touch. Thank you so much. Bye.
Yeah, have a nice day. Bye.